Good afternoon, Your Honor. Miles Drew on behalf of Mr. Ryan Busick, P number 84554. Mr. Busick, could you please state your name for the record?
Ryan Michael Busick.
This is a date and time set for PCC.
And Your Honor, at this time, I've made a request for the video and digital discovery in this that has not been tendered to me yet, so we'd be requesting an adjournment of the PCC.
All right, there would need to be a green sheet that would need, you may not be aware of that. We'll get you a green sheet to fill that out.
Sure thing, Your Honor.
All right.
Your Honor, just for the record, there was also the media discovery we have is in the discovery packet and should be sent over to counsel. And then I also called yesterday, have not received that yet, but it should be in route soon.
All right.
And Your Honor, we would like to address Brown when the court is ready.
Okay. You want the 26th or the 3rd, counsel?
Give me just a moment to check my calendar, Judge. The 26th would be fine if I could be accommodated, say at like 10 a.m. or later.
Well,
I haven't.
You'll likely be in more toward the afternoon, but I will set it at 9, and then we will place you into a block. We noted what you've indicated, but
Very good. Yeah, I do have a
if he's
hearing.
in custody, you'll be in the 9 o'clock block, I will tell you.
Okay, I may just be tardy for court then that day. I'll be coming directly from Medford.
All right. Yes, that's the bond.
As to bond, while I know the court heard me 2 days ago, I would note that, due to Mr. Busick having no record, these last 2 nights in jail have left an incredibly strong impression on him. Not only the seriousness of this case, but the importance of following all conditions of any bond or any court order going forward. He would like to get back out working so he can save his health care for his children and for himself. He would like to pursue a mental health evaluation. I have talked to clinical therapists, one named Virginia Dawson, who works closely with many courts in Oakland and Wayne County, and she's worked with my office for years. She has experience at the 48th and 16th District Court. I've confirmed that she has appointments that would be available to him every single day next week, depending on his schedule. So we would accordingly renew our request for a cash bond that Mr. Busick can afford of $25,000, 10%, Your Honor, with the tether, obviously.
Response from the people.
Your Honor, I believe the court knows where the people stand on bond. At this point, I'm going to object, given the fact of the bond violation originally, and then the facts of this case. I believe the bond that is currently set at this moment is appropriate for this case, given all that was stated previously on the emergency bond motion, as well as the bond violations that came up as part of it.
And the court would incorporate its findings a couple of days ago addressing the emergency bond. The emergency bond filed on behalf of the people, and particularly noting that after the point of arraignment, the defendant's conduct, I don't think, would lead the court to believe that this defendant would be able to follow all of the conditions as set without some cash component or significant cash component in place to try to assure his compliance. And also the court does believe, because of those actions, the defendant does pose a risk or threat to the community. And so therefore the court will deny the defendant's motion to reduce the bond in this case once again.
Would you consider a 10% provision on the current bond, Your Honor?
You asked me that yesterday 3 times, and so the answer is the same, no.
Fair enough, Your Honor.
All right.
I hope you and your staff have a good afternoon. Thank you for allowing me to make a record, as always.
Thank you.
Thank you.
Court does call the case of the people versus Wesley Brand.
Alexander, on behalf of the people.
Good afternoon, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Wesley Brand.
Your name, sir?
Wesley Brand.
All right. And this is the hearing that has been requested by the defendant regarding the violation.
Yes, Judge, my client at this time wishes to waive that bond violation hearing.
He admits to the violations
Yes, Judge.
regarding contact
I didn't hear you.
with Tanya Wilson.
Regarding the phone calls,
Yes,
if that was the question.
yes.
Yes.
All right. Court will accept the defendant's admission to the violations. I think his bond currently is set at no bond because of the violations or alleged violations in the case pending the hearing. Where do you want to go from here on this case?
We're asking for a preliminary examination, Judge.
You have all the discovery counsel.
Yes, Judge.
People have their witnesses available the 24th.
We'll do our best, Your Honor.
Does the 24th work for you, counsel?
It doesn't unless it's in the afternoon.
It would be all of the morning.
Right.
So
But let me look and see if I could get a better date.
We
You know
have
what?
the-
I'll take the 24th and I'll switch the other date.
So preliminary examination will be set in person, June 24th, 2025, 9 a.m. before Judge Freshour. Bond will continue as no bond is bond. I will revoke his bond at this time.
Right, Judge, there is one thing though that I wanted to address on.
Yes.
My client wanted to be able to call his mother. His mother has no connection to the complaining witness in this case, nor is he going to use her as a method of communication.
People.
Your Honor, I would just object that we can't guarantee that she would use her for third party communication. I just have
Yeah, I'm not going to allow that to happen at this point in time. I normally wouldn't have a concern about that, but the defendant has already decided that he wishes to engage in activities that would violate the privilege that he has to call people, to talk to people while he's incarcerated. So I'm not going to change that. His phone privileges are revoked in their entirety. All right.
Thank you, Judge.
Thank you, Your Honor.
Court does call the case People versus Holly Brown.
Ashley Lonnie for the people.
Good afternoon, Your Honor. Sam Bernstein here for Holly Brown.
And this was her motion to set aside her plea. I would indicate, and I don't know if counsel's aware, we received a violation.
That is correct.
Are you aware of the violation?
Yes, Your Honor.
All right. And she's not here.
That's correct, Your Honor.
Doesn't look like it, Judge.
Here, the people of this time would ask the court deny the defendant's motion to withdraw her plea. That doesn't mean she can't refile it later and issue a bench warrant.
I would just ask, instead of just denying it, I mean, it just doesn't need to go forward at this time and she can renotice it if appropriate later.
Well, here's part of the problem. Part of the problem is this was sent to Judge Freshour for sentencing.
Okay.
She files her motion to withdraw. Since I took the plea, it came back to me. And it's been sitting here while we've been trying to address her motion to withdraw the plea.
If it gets denied, it goes back to Judge
It
Freshour.
goes back.
I'd ask for it to be denied, Your Honor. Thank you. That's smart.
So what I'm going to do is, defendant having failed to appear, motion to withdraw plea is denied, and warrant will continue out. Her bond will be set at no bound at this point because I had issued a warrant based upon the violation that had occurred. All right.
All righty. Your Honor.
Court does call the case People versus Anton Brooks.
Joseph and Goldman, on behalf of the people, Your Honor.
And good afternoon, Your Honor. Assistant Public Defender, Shanazi Kyrie, on behalf of Mr. Anton Brooks, who's approaching. Mr. Brooks, state your name for the record, please.
Anton Brooks. Your motion.
Yes, Your Honor. At the last court date, defendant.
Excuse me. Have a seat.
Thank you, Judge.
Go ahead, sir.
At the last court date, the defendant had requested adjournment to retain private counsel after receiving a copy of the people's motion. I don't believe that has occurred. I believe that counsel after proceeding as court wishes, people rely on their plea for the court, but I don't want to speak for the defendant, for the status of his desire to take private counsel.
Thank you very much for that, Mr. Vengali. Your Honor, I was going to request an adjournment on behalf of my client. I did speak with him. He states that he has not been able to retain an attorney, Judge. He indicates to me that he's reached out to 2 different attorneys. They've both said that their caseloads are too heavy to take on anything additional right now. He, at the last hearing, did request a month, hoping that we would get that. The court gave us 2 weeks to see how far we've come. He states he only has his mother and his significant other. He has the funds to retain, or he can gather the funds to retain an attorney, but he just has not been able to secure a person who's willing to take on his matter. So he's asking that the court adjourn today and give him a little bit more time to continue working on that. I was just going to say, in regard to the people's motion, Judge, I know that, there is currently a search warrant that has been effectuated. I have explained to my client what could potentially happen, and the people listed that out in their motion. He does understand that. However, Judge, there's no urgency. It's not as if this is a situation where more time would, possibly negatively impact any results that they may get from that when it's received, Judge.
I will slightly disagree with counsel with respect, in that it is a valid court order. When it is defining compliance with that court order. We'd ask for remand in this matter for such time as a sample is willing to provide. And counsel and defendant have written notice from the people that each subsequent refusal to provide a sample could potentially result in an additional charge. And the case law that we're relying on is indicated in the briefs, and the counsel has copied that and discussed it with their clients. Cannot make any guarantees that should there be additional refusals, that there would not be additional charges.
And judges, should be noted that there is an additional case. It's an AWIM case that my office conflicted off of. That is the subsequent case. That is the case that was being investigated when the search warrant was given. So he is, do you know what your bond on the AWIM case is?
I think 100.
It's $100,000 cash or surety bond on that matter, which he is
So
not
another
able to pay.
case that he's also held on.
That is correct, Judge.
What I will do in this case is, his bond currently is 10,000 cash surety. Or is it 10?
It's 10%.
Okay.
Okay. All right. And granted, I have not heard the motion, so, and defendant seeking counsel. So I won't remand till he's compliant, but I do not think, given his behavior in not complying, at least at this point, with a valid order of the court, that I'm going to increase his bond in this case to $1,000 cash surety. I will adjourn the motion. How much more time is he going to need?
Judge, he's asking for past the 26th of June, 2 weeks, Your Honor. Right? What's
The
today?
26th of June. He thinks he can get it accomplished by then.
That's what he's hopeful for, yeah, Judge.
And I will adjourn. Actually, I think we're set for probable cause and the motion. Probable cause and the motion will be adjourned to 26, 2025, 3 p.m.
Thank you, Your Honor. Okay.
Thank you, Your Honor.
Court does call the case People versus Allen Ballou.
Good afternoon.
That's for the people.
Lawrence Margolis on behalf of Mr. Blue. Please state your name, sir.
Alan David Blue.
Judge, this is the date and time for PCC. We've been working with Ms. Douglas and everybody at the Veterans Court. And I believe this will be a referral to the Veterans Court. So I've been advised that I thought he was accepted, but I think there's more formalities that have to occur. So I'm seeking shortest adjournment you can give us, because I've spoken with Mr. Ashenfelter, I've spoken with Judge Valvo, I've spoken with Paul Graveline, and they all are very positive on Mr. Blue and his entry into the court. We've signed the paperwork. He met with Mr. Ashenfelter yesterday, or 2 days ago. 2 days ago. So I guess we're seeking a week. If
Well, I only have because of Juneteenth, I only have the 17th, which is becoming a loaded docket. And that's on a Tuesday, and I have the 26th. So
17 works for me. Is that
I'm here every time.
so the 17th, you
perfect?
think you can get?
Yeah. And if not, I'll let the court
Well,
and
so the motion for the PCC, as well as the motion for modification of bond, will be adjourned to 17th, 2025, 9 a.m.
thank you, Judge.
Thank you.
See you later. Honor, would I be able just to provide the court's copy to keep in the file if the court may be ready of the VA referral, or do you want that at a different time? Because I prepared the form thinking that I was going to be referred, that we were going to be referred today. I'll send it a different time.
Court does call the case of People versus Neil Kessler.
Thank you, Judge.
Jacob Kennedy, on behalf of the people, Your Honor.
Lawrence H. Margolis with and on behalf of Mr. Kessler, who is approaching, please state your name, sir.
Neil Kessler.
We are prepared, or we're asking the court to set it for an exam date.
All right. What about your motion?
We'd like to approach on that if Your Honor would permit us to.
Now, yeah.
The court wanted a follow-up on a case that he no longer has because he's that interested in the, how the defendant is doing. So I think it's important to let the court know he's doing very well. Thank you for that bench conference, Your Honor. So we're seeking an exam date, and Mr. Kennedy and I are going to get together and see if we can come up with a stipulation to present to the court in a timely fashion on the motion to modify bond.
So let's do it this way so that there's some finality to the ruling. Your motion to modify bond with reference to the issues regarding internet, I'm going to deny that portion of the motion.
Understood.
With respect to the issue of the house arrest tether, the court would entertain a stipulated order allowing for some type of limit on this defendant from the home on a curfew kind of basis. And that, so I will rely upon counsel to then prepare that order and submit it to the court prior to the exam date.
Thank you, Judge.
You have all of the discovery, Mr. Marcos.
We do.
Would people have their witnesses available the 24th?
Yes.
All right. Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington. Bond continued.
Thank you, Judge.
Thank you. Court does call the case of the people versus Dantes Williams.
Alexander, on behalf of the people, Your Honor.
Brian Bowling on behalf of Mr. Williams.
Name Dantes Marquise Bernard Williams.
All right, thank you.
Judge, we're here for a bond violation hearing. Based on my discussion with Mr. Williams yesterday, he would like to move forward with that hearing.
All right, very good. You can have a seat. And as I understand it, this is a part of a remand back from circuit court because of I think the addition or the attempt to add an additional charge of
assault with a dangerous weapon.
felonious assault. Part of that hearing, this is the bond part of it.
I apologize. We missed that, and I have a moment for the court pass this matter for a second.
Sure. How much time are you gonna need?
I don't think long,
I don't know.
but you know,
Whenever a defense attorney says that to me, why don't we take him back and then
Okay.
you guys.
famous last words, Judge.
Yes,
You know how it
exactly.
goes.
And then the court is standing brief recess. Just let somebody know that you're ready for me and I'll come back out. Court does recall the case of the people versus Dantes Williams. Counsel.
Sorry, Your Honor.
Go ahead.
Alexander, on behalf of the people.
Brian Bowling on behalf of Mr. Williams. Just state your name for the record again, please.
Dantes Marquise Bernard Williams.
Thank you. All right, I've had an opportunity to speak with counsel regarding the case, and there may be plea agreement that will be worked out. And here is the only problem, which I think is both in this court's mind beneficial to the people as well as the defendant. But the order which sent this case back down to the district court, I'm unclear as to the charges you were bound over on, whether the jurisdiction on those charges still lies with the circuit court, and that down here we could do nothing. So what I'm going to do is I'm going to adjourn it to the 17th, about 5 days out from now. I'm going to make a call with the permission of counsel to Judge Slay to try to make sure and clarify what her reading of her order is as opposed to my own reading. And if necessary, implore her, if necessary, to give us a new order if we need to, so that everything comes back so we can take care of it down here. Okay? That probably made no sense to you whatsoever, did it?
Yeah, but no, but yeah, it's like it could have been dealt with in circuit. So I
In
was
circuit court, I mean?
yes, so
Let me just tell you, I don't know what happened up there. All I know is it came back down to this court for a bond motion and for a preliminary examination on additional charges. So then I'm only going to be handling the bond motion part of it. So, but counsel to have been working really hard to come up with something that would be a good solution, I think. And so to give that a shot for it to happen, I'm willing to adjourn this out 5 days, do what I can do to try to clarify it all and see if we can get it done down here. Okay? If you have questions on it, ask for your attorney. He's a smart guy. All right? Okay? So bond will continue as it is right now. I'll adjourn this out to June 17, 2025, 9 a.m. All right? Thank you, folks.
Thank you, Your Honor.